Good morning. Thank you for having us here today. We're really excited to be talking to you about the ways in which we use our data in civil legal self-help and civil legal assistance programs. Let me start by introducing myself. I'm Jamie Walter. I'm the Research and Analysis Program Director at the Maryland Judiciary's Administrative Office of the Courts, and I'm here with two of my colleagues. If you'd please introduce yourselves.
Good morning, everybody. My name is Lonnie Summers, and I am also happy to be here with you today. Thanks so much for having me. I am a senior program manager with the Judiciary's Access to Justice group. Prior to that, I was a legal services attorney doing primarily housing and consumer work. And in my current role, I work with courts and nonprofit legal services providers to support programs that enhance access to justice. I work very closely with the Judiciary's statewide network of court help centers and oversee grants to providers of day of court representation programs in jurisdictions throughout Maryland. Justin?
Thanks, Lonnie. Hi, good morning. Justin Bernstein. I'm a researcher in the research analysis program of Jamie's group. I do work with Lonnie and other folks in the Access to Justice program and work on a variety of other projects in the Maryland courts.
Thank you. And Justin will be moderating and watching your questions come in this morning. We'll be addressing them along the way, but if there are some that we know that we're going to get to in our talk, then we're going to hold off on them. So, okay, so before we begin with the specifics of self-help program measurement, outcomes, and data, we need to think about why we collect data in the first place. We do not collect data to have it gather dust. We don't collect it so that it becomes another report that is put on a shelf or, God forbid, that it's in the deleted folder of someone's inbox. We gather data because we want it to be useful. Data needs a purpose. So data collection and data analysis always needs to be done in the context of whatever questions are being asked. So as an evaluator, step one for me always needs to be, first of all, what question are you trying to answer? And then once you know what those questions are, then we can think about how to get to those answers. So I tend to think about it in two frames of reference. One is that we're gathering management information about program goals and the use of resources. And we're also gathering data about accountability measures, about a program's effectiveness or management or governance effectiveness. And sometimes we're gathering data on both of those. So once we know that, once we know what the questions are, what frame of reference we're putting it in, then we can look at what data would answer those questions. So for instance, if we want to know if the calls coming into the self-help center are being answered in a timely manner, we need to look at call data. So the next part of that is then, is it from data that's already available? Do we need to collect new data? And if so, how are we going to get it? What's the best way to get that information? Okay, so in this talk, we're going to be discussing, we're going to start by giving you an overview of some of the Maryland self-help and legal aid resources to give you the context for the data that we collect. And then we're going to be walking you through some examples of our management data and our evaluation research data. And in each of those, we're going to be talking about some of the lessons that we've learned doing those evaluations and some of the lessons we've learned in looking at that data. So, okay, great. Let's hand it over to Lonnie, and she's going to be giving us an overview of the Maryland help and legal aid resources and some of her management data.
Thanks, Jamie. So the Maryland Judiciary has many programs that aid the self-represented litigants, and these programs range from legal information to legal advice from our help centers, as well as day of court representation programs. And the Maryland Court Help Centers are sort of one of our flagship programs. We are very proud of them. But before I do an overview of those, I really want to mention that the judiciary is right in the middle of a rebranding. And so we used to call these programs self-help centers. We're moving towards help centers, just streamlining a little bit. If you hear us slip up, which you probably will, help centers and self-help centers are the same thing. So that's what that's about. So Maryland Court Help Centers have been around since the mid-1990s, beginning with family law walk-in centers, which we currently have in every single jurisdiction throughout the state. We also have district court help centers, which assist litigants without counsel in our high volume district court case types. So those are landlord and tenant, consumer debt collection, small claims, expungement, those types of cases. And last but not least, we have a remote service center, which provides legal advice and information to litigants without counsel in all civil matters. So this is everything from family law, landlord-tenant, expungement, and everything in between. Our remote services center is open for extended hours from 8:30 in the morning until 8 at night. And the services are available via phone, live chat, and to a little bit of a lesser extent, email and video. Most Maryland Court Help Centers provide legal advice and information for litigants who are unrepresented. So this includes help completing court forms, filing court documents like motions and answers, preparing for court hearings and trial, mediation, as well as understanding court documents. Often people will come in with after being served with court papers, and they just don't know what to do next. I was served with this, what should I do? And of course, finding a lawyer for those who either cannot or should not represent themselves. So a quick note on staffing, which I'm kind of laughing because it's at the bottom of the slide, but it's sort of important. Maryland Court Help Centers are staffed in a few different ways. We use many different models actually for staffing. Some use court staff, others use pro bono attorneys, and still others use contractual providers. It's important for this presentation, though, because our district court help centers and our remote services center are operated by one contractual provider. And these two programs provide more than 97,000 instances of service every year. So we've got one provider doing the majority of these consultations. So there are benefits and drawbacks to each of those staffing models, but that's not what we're here to talk about today. So one benefit to having one provider for these two large programs is that we have contracted with them for certain things, for example, data collection. So what data do we collect? All kinds of stuff. We collect case type data, litigant data, satisfaction data. Jamie mentioned this earlier. While we collect a lot of data, we really make a point to only collect data that we are going to use. So what do we use the data for? Some of the data we use to advocate for programs. When the district court help centers opened, we had a little bit of pushback from the private bar. You know, why is the judiciary providing free legal advice? Isn't this the role of attorneys? Shouldn't they be paid for this? And we used income data that we had collected, which showed that the overwhelming majority of people who use judiciary help centers have a lower moderate income, meaning they're legal aid eligible, they're not able to pay for private counsel. And this really helped justify program existence. So next up, we're going to look at a few examples of management data. And this first slide shows help center demand from our remote services center during the evening hours between 4 and 8 p.m. Why is this important? Well, you can see on the left-hand side, right in the middle of your screen, in October of 2015, when we first launched the evening hours, we had a low demand. A lot of people were not really calling and chatting between 4 and 8 p.m. But we've collected this data over time, and you can see that the demand has really increased. And this helps us make decisions about program hours and staffing. So if nobody's using the service between 4 and 8 p.m., maybe we shouldn't be open. This next slide compares telephone volume year over year. You can see January of 2020, that's the blue line, and underneath it, the red line is January of 2019. And this chart helps us look at staffing and budgeting for the overall program. So if you look at this chart, we can make decisions about the hours that the attorney staff should be working. Should they work from 7 to 3? Should they work in the evening? You know, peak hours, as you can see from this chart, are between 9 and 2. So we can consider when people need to be taking a lunch break and when, you know, we should add more staff. The other thing I mentioned was budgeting. Looking at year over year data, you can decide whether you need to add staff, you know, to meet the demand. This chart looks at overflow telephone calls that are being answered by non-remote services staff. So what does that mean? Remember, we've got one contractual provider in Maryland who staffs the remote services center as well as the district court walk-in centers. And if the call center is getting backed up, they have a huge demand of telephone calls or chats, and wait times are increasing, the walk-in staff can actually log in and pick up those calls from the walk-in centers that you can see listed on the right-hand side of your screen. And this chart helps managers identify locations that may need to be taking more calls, or maybe walk-in centers that are too busy to take calls. Maybe you need to add staff there. The other thing that we've used this chart for, which I find very interesting, is to inform training. So we found that one particular center was not taking very many calls, and it turns out that the staff there were not comfortable handling family law matters because they were used to doing the district court case types. And so we got them some training, and sure enough, they started picking up a lot more calls. Okay, so as I mentioned earlier, we collect a lot of data from litigants, and we've been collecting a lot of data over a long period of time. And again, it's important to continually evaluate the data that we're collecting and how we are using it. And so when we put this chart together, we were looking at demographic data over time. This particular chart shows the age of walk-in help center users over a 5-year period. And as you can see here, there's not a lot of variation, right? The data does not change significantly over time. Collecting data from litigants takes a lot of time. It takes time from the staff that's collecting it. It takes time from the litigants who are providing the information. And on the telephones in particular, it takes about a minute of talk time in order to collect this demographic data. And when you're handling more than 60,000 calls a year, a minute of talk time really adds up. And so what we found was that attorneys were spending a lot of time collecting data and not spending that time giving the legal advice. And so we wanted to stop collecting this data from every single user. But, we, of course, wanted to consult with Jamie's folks, research and analysis, to get their input on whether or not we could do that. Should we do this? Can we sample? Sort of what are the best practices? And Jamie said...
I said that was fine to do. Yes. Thank you, Lonnie. Yeah, the call center has some really great data that they use for these management purposes. But we also look at that same data for evaluation purposes as well. In fact, that demographic data that Lonnie was talking about was incorporated into their business process. Collecting that data was part of their regular business process at the formation of the very first walk-in, what we used to call the self-help centers, now the help centers, when they were first formed, because we were evaluating those centers at the time and we really wanted that data. So that was part of the evaluation of our first evaluation of the self-help centers in 2012. I'm going to be talking about the next 3 more recent projects and some of the findings and lessons learned. So this is some of the research we've done on a statewide level. I do want to mention that Maryland was also one of the participating states in a national research project with John Grecian and the Self-Represented Litigation Network. But so we're going to be talking about the Tenant Volunteer Lawyer for a Day, mode of service delivery, and then the most current project, our self-help or help online chat and walk-in evaluations. So starting with landlord-tenant or Tenant Volunteer Lawyer for a Day. Again, the context is important. So I want Lonnie to, as the grantor, this is a grant program, I'd like her to give a little background on what this program entails.
Sure. So several years ago, my department began funding a grant program that provided day-of-court representation to litigants without counsel in high-volume consumer debt collection matters, which we called the Consumer Protection Project. And in fiscal 17, we decided that we would try this same model in rent court. And so we launched the Tenant Volunteer Lawyer of the Day program, which connects litigants with pro bono lawyers who represent them in rent court on the day of trial. And this program helps identify legal issues like improper licensing or fees, housing conditions that affect life, health, and safety. And as you know, courts have limited resources to devote to programs, and we wanted to make sure that these programs that we are funding are actually efficient and effective and serving litigants in the way that both the grantee proposed and in a way that is appropriate for a court-based program, to be doing. And so again, we went to Jamie and her folks for help on evaluating this new program, the Tenant Volunteer Lawyer of the Day program. And we worked with them as well as some colleagues in the court where this program actually is housed in Baltimore City, which is one of our higher volume rent court jurisdictions. And we developed these evaluation questions that we wanted to answer.
So, as Lonnie mentioned, that she approached us and we talked about some of these. We framed the question first because, again, framing the question helps us understand where we're going to get the data, what kind of data is already available. So, in order to answer these questions, we need to break these down. What are the actual questions? What data is readily available? So if one of the deliverables, so is the program meeting its deliverables? If one of the deliverables is that a certain number of clients need to be served, then we need to ensure that the grantee is capturing this data and that we can get access to the data. As you can see, there are also questions about access to justice, outcomes. So we need to look at various data collection methods through surveys and court observations to get to that. And this last question that they have about whether the program should be expanded, that's one as researchers that we always tread very lightly on. We do comment about whether a program is performing well, whether it's meeting its goals, and to the extent that we can, we comment on any gaps based on what the data shows us, or if there are stakeholders that see a need for the program in other areas, meaning other court locations or expanding it to other case types. So let's turn now to some of the data, which I know probably a lot of you are most interested in seeing. So this is using court exit surveys. You'll see in the dark blue tenants that were in the program, meaning that they had a volunteer lawyer for the day. And then the gray is the tenants who appeared in court that day that were not in the program. And what we found was that there was a higher percentage of tenants in the program who agreed or strongly agreed, excuse me, that they were treated with respect, that the judge listened to their side of the story, and that the judge had the necessary information to make good decisions about their case. Now, in terms of, as I mentioned, we were in the courts observing, and these are really fast dockets. So we were watching, we could see what was happening in court, we could take note of it. And we found that tenants in the program were more likely to get a continuance in the case, and they were also more likely to have a rent escrow action. We did find a variety of other findings that I don't have time to get into, but I want to talk about some of our lessons learned in this. So our lessons learned, there are really, I would say, 3 lessons learned, as you'll see up here, and they're really all related. This, as I mentioned, is a really fast docket. People want to get in and out of there quickly. So we had researchers from my staff on site who could follow people from the court, hand them a quick 3-question paper survey, and we had drop boxes for their replies in a box by the elevator on their way out. But we had to be adaptable because in some cases we had tenants who would say, I'm happy to fill it out, but you need to walk with me. We need to walk and talk. Like, I'm late, I got to get back to work. And so we were perfectly fine with doing that. And we would just follow them sometimes down the elevator and then run back up, put the answer in the drop box, and then run back into court. So if you're familiar with the National Center for State Courts Access and Fairness questions, you know that it's not 3 questions. And while it's a great survey, it's okay to adapt it as needed. And for this particular project, knowing what the context was, we felt comfortable with limiting it because we felt like a longer survey would mean a significant drop in our response rate. Fewer people would stop and take the time to complete it. And so, for us, being quick and adaptable is incredibly important. I just wanted, before I move on, I really need to thank 2 people who worked really hard on that project, which were Brad Powers and Kate Marr from my staff and their work on that project, because they were the ones that were chasing people down the hall in court every day up in Baltimore City. The second project I want to highlight is one that we worked on recently, looking at mode of service delivery. Mode of service delivery for the help centers, meaning phone, chat, email. I mentioned the last full evaluation we did that was finalized in 2012. And when that evaluation was finalized, this tends to happen sometimes in evaluation research. The thing you're evaluating is changing while you're evaluating it. So as the data collection and analysis was happening, the program managers were ready to move on and expand, and they started doing phone, chat, and email. And that wasn't considered in part of that evaluation. So we wanted to see what the impact of that was. So Lonnie, you want to talk briefly about the data collection that we did for this?
Yeah, so this particular survey looked at the mode of service delivery in family law matters, and we looked at phone, live chat, and walk-in to try to determine which method of service delivery people preferred. And so we worked with research and analysis to develop and administer a survey to evaluate self-help services across these different platforms. And our goal was to capture the impression of users immediately after receiving the services. We used paper questionnaires for walk-in litigants in a couple of jurisdictions. We used an automatic survey that was built into our chat service. And then for the phone, we actually had attorneys present litigants with the opportunity to participate in the study after the consultation, and they could provide their responses by phone.
So thanks, Lonnie. So as you can see, overall, people are very satisfied. 94% of participants agree or strongly agree that they were satisfied. But that misses the story, because then we drill down and you can see that the mode of service delivery makes a difference. So walk-in surveys, they had the highest marks for client satisfaction, with 99% of participants strongly agreeing or agreeing that they were satisfied with the services provided. Phone satisfaction was 97%, and chat is still high, but it's a little lower at 82% of users agreeing or strongly agreeing that they were satisfied with the services provided. We see a very similar pattern with the question we also asked, which was, I understand my case better. Agreeing or strongly agreeing with the statement that they understand their case better after speaking with a help center attorney. We asked the same question about them feeling optimistic about their case and had the same pattern of results. But our lessons learned, so what are our lessons learned in this case? I think certainly the quantitative survey responses are telling us a very important story, and it's important based on the drill down. The percent agree is really meaningful information. But in this case, we also felt it was important to get open-ended responses, something that we really obviously could not do in the rent court study where we're chasing people down the hall. This time we had the time to ask open-ended questions. And what we found was that, well, there were not a lot of negative comments. There really were not a lot of them. We did find that the only people who gave negative comments were the chat participants. They were the only source of negative comments. So those comments are really helpful for program managers to make program improvements. One of the things I think is really interesting about a study like this too, even though it's a really small scale one, is I think a lot of times asking good questions can lead to more questions, and it can lead program managers to think about why. And you can use those questions and follow up and use them as a source of getting funding for program enhancements. So one of the questions I asked, why, is there something about the live voice that you see in phone and in person that is an overall benefit over a web-based chat? And what are the privacy or convenience pros and cons that litigants are thinking about? So that then leads us to, or the program managers, to thinking about things like video conferencing.
So as Jamie mentioned, one of the takeaways from our mode of service delivery survey was that phone and in-person service delivery had better ratings of satisfaction from users. And in Maryland, we have been working on how to get in-person help centers to all jurisdictions, even the really small ones. It's a matter of court equity. And some jurisdictions statewide just may not have the number of civil cases, for example, to justify a full-time help center. But if you're the litigant who comes on Tuesday for help with your custody matter, only to find that the help center in your court is only open on Fridays from 9 to 1, that's super frustrating, right? It's better if we can offer these same services to everybody regardless of location. And so we use the information that we gleaned from this study to really inform what we could do to expand access to court programs while also retaining some of the characteristics of the in-person service, which of course got the highest marks. So this led us to video conferencing. And this sort of makes me laugh now because everybody's video conferencing now, but at the time it was kind of cutting edge. Not a lot of people were using video conferencing. Of course, I would be remiss if I didn't mention that some courts, Alaska for example, have been using video conferencing for years. But a lot of people in the general public just weren't really using it, maybe FaceTime or something like that, but it just wasn't as widely used as it is now here in the middle of a global pandemic in 2020. And so when we first tried to roll this out last year, we found that litigants were a little bit reluctant to use it. Staff weren't crazy about doing video at work, which really makes me laugh because that's all. I haven't had an in-person meeting in 7 months. Everybody's doing it now. And so we have been using video extensively at our walk-in centers since March to facilitate safe quasi-in-person interactions. And we really hope to expand this further in the future, in the coming years, to achieve our goal of having full-time in-person help centers in every court statewide. And so this brings us to our latest collaboration between Access to Justice and Research and Analysis. I have been working with Jamie and Justin to look at help center services as they stand now. Jamie mentioned this earlier. We did an evaluation way back in, I think it was 2010, 2011, before we even had phone and chat services. And we really didn't have much data on the effectiveness, and we wanted to update that study. It's a little bit stale. And so we reached out to Jamie and Justin, and they have been working hard for the last couple of years on this study, and Justin's going to provide some details on this current evaluation.
Thanks very much, Lonnie. Just before we get to that, I have a question from Bonnie in California about the comments about for the mode of service. Were there any comments about wait time for in-person service?
I have to go back and look. I don't remember that that was a particular concern for the in-person service. Again, they were extremely positive responses. And that's something that you'll see. We did a similar thing with this one where we're asking people as they were leaving the self-help centers and the walk-ins, and they just sometimes you have to stop them because they have so much nice stuff to say. They just want to go on and on about how much they enjoy it. But I could go back and look and see if there were particularly comments about wait times and get back to you on that.
And Kelly from North Dakota asks if the parties have to come to the courthouse for the video conference with the help center or access from home. I assume they can do it from a home because all the other remote services are. Oh no, they have to come to the courthouse.
They do.
I apologize. I stand corrected.
That's okay.
My mistake. Okay.
So that's.
I think that's a model that they use in Northern California too, if I'm not mistaken, right? Where they have video remote locations at the courthouse, and then that transfers them into an attorney.
And that's what we're looking at doing to get this rolled out to all the court locations first, and then we'll consider whether we want to roll this out and do, offer that on the website or, where people could chat video conference from home or other locations. But first priority is to get these little kiosks in court locations statewide.
Thank you. Sorry about that. Thank you. So
before you go on, let me just comment that it makes some sense to do that also, because a lot of the traffic into the self-help centers comes from people right as they leave court, and they're like, I don't know what to do, or they go to the clerk's office and the clerk says, you really should go to a self-help center or help center, and then they can direct them right down, or there's a kiosk right there. So in some ways it'll be more convenient for them because they don't have to then go home and then remember to do that and find the link because it's right there in the court.
Jamie's right. We collect data on referral, like how people were referred to the help centers, and the majority of referrals come from either judges sitting on the bench or clerk's office staff. So people are already in the courthouse, or they've come to the courthouse knowing they have some kind of a legal problem. They may not be sure what it is or what to file. and it's convenient if they can just be referred to an attorney right on site or kind of on site.
Okay. So switching gears a little bit. So I'm going to be talking a bit about the most recent work that we've alluded to a couple of times, which is an evaluation of the help centers providing limited legal services for the unrepresented civil litigants. As Jamie mentioned, there was an evaluation back in 2012. It was quite some time ago, but as you saw from some of the earlier slides, those have expanded quite a bit since then, and now, to many more locations, and of course also the remote services. So you can see there's a lot of moving parts to the program, and so we approached the evaluation in as many ways we could. The main data collection for the evaluation was on site at the help centers and courts. You can see from this slide that we'd intended to do follow-up with people with their permission, and we'd collected contact information for people who consented to that. But the world intervened, a small matter of a pandemic, and it just wasn't feasible from a practical standpoint with everything else that was going on. And also, taking a step back, we thought about it and realized if we surveyed people during the pandemic, that's going to affect their responses. There might be context in which you want to look at the effect of the pandemic on people's experiences, but that's wasn't what we were studying here. So we decided, if we can't make defensively valid inferences from the data, we're not going to collect it. Tying back to the themes throughout, that making sure we're collecting the right data for the right questions, and also being flexibility and adaptable. In addition to the surveys, we had 3 other data points. We did interviews with judges, key stakeholders. We want to know about self-represented litigants in their courtrooms. The help centers, as we've talked about, make a lot of referrals to other providers and vice versa. Wanted to get their views. And the help center attorneys themselves, right? This wasn't a game of gotcha. We want to talk to them, get their perspectives. It's actually not on the slide, but we did also survey clerks, the frontline workers who are often who the parties are talking to first. And it can, they're in a difficult position because they want to help, but it's very limited what they can do when someone comes up to them. But they can send people to the help centers. So most of the effort for the surveys, the main data collection, was from our team of research assistants. We had 5 of them on this project. We posted the position on the Judiciary website, and additionally, we reached out to some schools leveraging existing relationships and connections that we had with schools in the area. For this particular project, we didn't have law students. We have in the past worked with them on other projects, but the timing here wasn't right for that, and I'll talk more about that in a moment. We hired a combination of current students and fairly recent graduates, ranging from one person who had just finished her first or second year of undergrad to one who had just finished her master's, the rest in between. And they had a range of experience. None of them an overwhelming amount of experience, as you might expect. But aside from the
Hello, we're back. And if you were working on your 2020 bingo card and you had in there somewhere that during a live presentation that the whole building would have a power outage, then you got your bingo for today. So let's pick up where we were. We'll try and talk quickly through some of these since we lost a few minutes. But before we do, I just want to thank Jason Wamball and Eric Hansen, who did so much behind the scenes to get everything back up for us. So thank you very much to the 2 of you.
here.
Justin.
Okay. Yeah. Thank you guys again. Okay. So okay. All right. So as I mentioned, we did we spoke with the judges, the help center attorneys, and the help center attorneys, excuse me, and the providers, and also we did a survey with the clerks. And so we were working with research assistants with a range of experience, and aside from their experience, when we interviewed them, we were looking want to make sure that they were comfortable talking and be able to engage with the respondents, right? And working with interns means, for the most part, it wasn't staff. So having our full-time staff doing it, you might get higher yield or better data quality potentially. But in terms of use of our resources, having staff in the field as opposed to doing the other things they had deadlines on, always balancing best use of human and other resources. We found research working with the interns with the limitations that entails effective, so balancing as with everything else. I'll come back to budget in a moment, but as I mentioned, different level experiences. Working with interns definitely need to be attentive to training considerations. We brought folks in for a day of training. Wanted buy-in from them, especially given that many didn't have a ton of experience. We spent time on this project and their role in it, but also on the Maryland judiciary generally. But I think the most important part was practice, role plays and so forth. The main thing was trying to keep things fairly straightforward. excuse me, don't want to say simple because it's not an easy thing to walk up to strangers in a courthouse and just get them to start talking to you, but clearer and without unnecessarily complicated instructions or methods. Somewhat rigid, the interns are going to be on site largely unsupervised. So we wanted to ensure as much as we could that the results were going to be from the survey respondents and not because of idiosyncratic differences between the surveyors. With the students with a lot of experience, training is not going to be a one-off thing. We could just do once and then forget. I was in pretty frequent contact with them throughout. We had weekly check-in calls as a group, and I made sure that they knew that if there were any real issues or problems, not to wait for that call. And some, ongoing oversight and training to the extent we could, pretty key. So budget, need to be mindful of using paid interns. Obviously, going to affect budget. Right, 5 people paid hourly, even if you're not paying them very much, more or less full time, that adds up quite quickly. Just something to keep in mind. The adage that the day a project starts is over budget. Budget's being even tighter than usual these days. Hopefully, at some point, research assistants can be a bigger line item. But if you're not in a position to pay interns, that's going to affect who your applicant pool is. Although some schools might require unpaid internships too. As with everything else, sort of balancing. Timing with the school year, I mentioned that we didn't use law students for this. We were doing this over the summer, starting out in early July, I believe. It wasn't that we wouldn't have taken any, we just didn't have any applicants from law school for this project. In the past, when we've worked with law students, we've had the most success late summer, which is ordinary year, of course, after the bar exam. Just something to keep in mind if you're doing a project, think about hiring interns, particularly law students or law grads. I just want to quickly. Sorry, I want to make sure I have the moderator window open over here when things, okay, good. So in case I can see any questions that come in. Okay, for this project, we were able to keep a couple of research assistants on for longer, but for the ones who were still students, we knew we had to be flexible with them, students first, particularly as it got later in the summer. And by the end of the summer, most of them were back to school. So we as we've mentioned, we collected data multiple ways. This was sort of part in iterative development. We did most of it on judiciary-owned tablets. Our department, we have a Qualtrics subscription. I'm sure many of you folks have used it or have taken surveys on it. It's an online survey platform similar to SurveyMonkey, if you're more familiar with that, which brought its own challenges. For example, not all our courthouses have reliable internet access wireless access throughout the building. Fortunately, we sort of checked this out during our site visits preparation before we put people in the field. So we upgraded our subscription to include an offline app, which I had never used before. Pretty neat. So download the survey to the app. So the tablet stores each set of responses, refreshes to blank, and then once the tablet is someplace with access, it uploads it automatically. I mentioned it was an iterative process. We found we weren't getting as much success with people coming out of court as with the help centers. Originally we thought we'd do everything on the tablet, which gives us the added benefit of automating data entry. But when we were having that trouble, Jamie suggested, how about a paper version? And some people definitely responded more favorably to that. For the most part, we gave people the option. Also want to make sure we had paper as a backup, right? If you're doing this for when technology fails, case in point, or if you suddenly have, several people and only one tablet. The last thing you see on the slide is multiple languages. We knew from Lonnie's existing management data that although most people using our help centers, they're English speakers, there's a non-trivial number of limited English proficiency clients. Courts, of course, no different. So with our constraints, it wouldn't have made a good use of resources to translate surveys into every language the clients speak or that the litigants speak. But at the help centers, they have language line that they use. I'm sure folks are familiar with that. But we did work with staff at Access to Justice, Lonnie's group, which also handles our language services. She worked with us to create a Spanish version, which from the data we know is, not surprisingly, the most common language other than English from Lonnie's data. So as I mentioned, we had separate surveys. The first was for people exiting the help centers. I'm saying exiting, but it was also for clients using the phone and chat remote services, so not just physically exiting. The second survey was for people leaving court on civil hearing days. The help centers only do civil, so we want our comparison group to be limited to civil, of course. So, of course, our initial screening question, as you can see, is, did you represent yourself in court today? We also had a language screening question so that if for the English survey, basically you only saw English questions. For the Spanish, only saw Spanish. As you can see on the slide, there's a lot of information on the slide, and if you had both languages there side by side, it would just be unreadable. We asked them about, among other things, the court experience. As you can see on this question, some of these questions might look familiar. We adapted the questions from the trial court performance measures access and fairness survey to avoid reinventing the wheel as much as we could. On the right, you see the Spanish version, trying to keep things compact. And just a little bit of results from the Help Center survey here. I'm not sure about other states. In Maryland, we don't generally track repeat visits. As we've talked about throughout, if we don't plan on using a piece of information, we don't need it, we don't collect it. And also this avoids conflicts issues. So anecdotally, we knew there were a lot of repeats just from talking to Help Center staff. This was our first time sort of looking at numbers showing a majority of Help Center clients really had visited 2 or 3 times. And to me, that was in and of itself interesting, speaking to client satisfaction, and also put some context on numbers that we usually report about in terms of instances provided, as Lonnie mentioned previously. Next slide, please. Thank you. So the main reason we collected information about sort of the help provided, we want to make sure that the people we were getting for the surveys, they were there doing similar things to what we knew from Lonnie's management data is what the help centers are doing, right? It's not that we have a random sample, we don't, but we want to make sure that it was fairly similar. And you can see, a lot of forms, documents, case information. And we were, of course, very pleased with the Help Center satisfaction, as you can see, overwhelmingly very, very positive. Average was 4.5, with 5 being strongly agree being better for all the questions, the way we phrase the questions. 4.5 or more across the board. Convenient, 4.8, wait time, 4.5. Understanding legal issues, knowing next steps, help taking the next steps, each 4.7, recommend 4.8, all very positive. I think next, I'm going to turn it back to Jamie, so this was the first part, the Help Center interviews. I'm going to turn it back to Jamie, who's going to talk a bit about the court exit surveys.
So as Justin mentioned, we wanted to see if visits to the Help Center affected their experience in court. We also wanted to be able to compare them to a typical court user. So we needed to gather data as people exited court. So one thing we found was that the decision that was made in the case was not really profoundly different, and that's not a bad thing. The self-represented litigant is not going to get really vastly different outcomes. That says something about the inherent way the courts are operating. So this wasn't really a surprising finding for us. I think what we wanted to see, or what we see next, was in the court exit surveys that when comparing the Help Center visitors, those are the ones in blue, to those who did not visit a self-help center, the ones in gray, those who had visited felt more prepared in court. So that is what we were expecting to see. And also, I think one of the interesting findings we have is that when they leave court, they know what to do next about their case. So self-help centers visitors again in blue, and then those who did not visit in gray. Something else that really stands out to me about this data, though, is that a lot of people don't know what to do next. And especially for the non-court users or the non-self-help center users, not knowing what to do next. But it makes me think that we need to do something. We may need to think about it in the judiciary about what kind of information we give to people as they're leaving court. So we also did, as Justin mentioned, we did some interviews with various people, and one of them is judges. And for that, Justin had mentioned that we used interns for a lot of this project. This was not something that I would feel comfortable having interns do. This is something where you really need to have your skilled staff, people who will know. These are very fluid, and you're going to have follow-up. So it's important to have somebody who can kind of speak the language and is comfortable talking to judges and knows what kind of which questions to probe about, which questions to know that it's a good answer or a satisfactory answer, a complete answer. And so Justin did all of the judge interviews. So Justin, you want to talk a little bit about how those went and some of the comments you got?
Sure. So yeah, thank you, Jamie. As we've talked about, we tried to get at this project from as many different angles as we could. So we did brief interviews with the judges for their perspectives, a number of reasons you want to include them. And again, as we saw with the surveys, overwhelmingly positive. And something they talked about a lot which I hadn't really fully thought about beforehand. It's not just that the motions filed are better, as you can see from sort of some of the excerpts. And Jamie showed that the formal court outcomes, it's not a huge difference, but sort of the perception of legitimacy and having a voice, right? They feel like the system is not against them. They have some say in the process, and it helps them feel less frustrated. The formal case outcomes are, of course, important, but they're not the only thing that's important for doing justice and for being seen to be doing justice. And to me, I thought that was, I think sometimes it can be easy to overlook that, but it's an important outcome as well. I think, given the time and the disruption, Jamie, I'll toss it back.
Okay, so what are our lessons learned? I would say for the Self-Help Center, it was a lot easier to get people excited to tell us about how great the surveys were, how great their service was. But for the court exit surveys, it was certainly more of a challenge to get people to stop and talk to us and talk to the interns. So you got to come early. After our time with the interns was up, I looked at the data and I felt like there were some locations we just didn't have enough responses yet to say that we were really thorough. So all of the research staff here went out and visited the courts, and myself included. And what we found was that coming early, coming before court starts, introducing yourself was really important. Getting so that way the people who are about to go to court are familiar with you and they know when you're following them out of court, why you're there, and you're already kind of a friendly face. Debriefing with the interns was really important. As Justin mentioned, they're learning. It's a process for them, and this allows them to get feedback and learn from each other and talk through things that went well and things didn't go well. For the judge and referral interviews, I think coordination is key because you're going to need to track people down, to work with the clerks or secretaries to find time to schedule interviews. And because it's more open-ended, it's important to save these again for your more experienced staff and not have your interns complete this. So now what are our final lessons learned? Again, the data should always tie back to your goals. The data should tie back to the questions you're asking. Make sure that you're answering specific questions. So that if that means going back to the program staff and talking, like Lonnie is fantastic because we've worked with her enough that she's becoming a researcher in her own sense, and she can think about like how to frame questions to us so that we can help answer those for her. Be prepared, of course, be prepared when you go into any research project, but always be adaptable. You want to have your research, you don't want to change horses midstream and like radically change your questions you're asking, but you should take time to reflect on what's going well, what's not going well. Maybe you need to start doing paper forms. Maybe you need to be able to chase them down the hall. Maybe you need to scrap your 3-month follow-up because we're in a pandemic and people might not say they're particularly happy anyway because of their on lockdown. And so that might be important not to collect that data after all. And I would say when using interns are a great source of help. As Justin mentioned, there are paid and unpaid interns. Law students we've used, sometimes we find them that they are in this gap between the time when they've taken the bar and then are waiting for their bar exam results. So that tends to be a good time to be able to use that as a resource if you have particular things that a law student would be helpful with. But then there are a lot of programs where they require people to do internships, so they can be a great source. And then with them, you want to train and retrain and keep dialogue open with them. So with that, I'd like to open it up for questions from you all, if there are questions in the chat.
I think there aren't any in the queue, but if anyone has ones that they've been holding back on.
While we're waiting, Lonnie, do you have any comments you'd like to make about your use of data and some of the things you've learned before we wrap up?
Sure. So one of the things I can mention about the survey that you did on Tenant Volunteer Lawyer of the Day of Court program, This particular evaluation was helpful for us to demonstrate to the grantee some areas that actually needed improvement, like some program performance issues. So for example, the evaluation that you all did showed that there was a lower than desirable number of clients that were being served. And that was something that we worked really hard over the first couple of years with the grantee to address. And so we recently, I put together the data reports for last fiscal year, which ended in July. And of course, that fiscal year was notable because the courts were closed to the public for more than 25% of the program year. And even with that closure, the program assisted 16% more tenants than they did in the previous fiscal year. So it's just great to have that baseline sort of performance data where we can measure and really work with the grantee on things that we can do to increase the number of participants.
Okay, so Bonnie from California asked how many people we were able to talk to. I don't know the number off the top of my head, but it was several hundred overall. It was throughout multiple sites, but it was several hundred from a variety of places, if that makes sense. And then, sorry, go ahead, Jamie.
We didn't, in our smaller court locations for the court exit surveys, we wanted to make sure that the minimum number we had was 10, which is, in one court location, it was as small as 10, or I think it was 11 actually, but then in larger jurisdictions where there's a lot more volume, we were able to get a lot more. But as Justin said, it was a couple hundred. Other questions?
Sarah from Williamsburg asks if we're able to calculate a survey response rate. We don't know the number of people, for example, who visit the help centers overall, because that's not data that the help center tracks, right? Because they're looking at it in terms of instances of service. So that's not something that we could calculate. And then in terms of the court surveys, I mean, there's not really. If there is a way, I'm sure someone cleverer than me could come up with it to sort of keep track of the number of people coming in through civil dockets. Right, but while on that day we're there, who showed up. We did not, is the answer to the question. No, but
it's hard to know exactly what the baseline number would be for the court exit surveys, because some people come out and say, our first screening question is, did you represent yourself? Or can we ask you a few questions? Did you represent yourself? No, I didn't. And they just keep walking. But I do think, to get to your question, there was a lot of variability in terms of different people being more successful than others. I think it's definitely a talent, but it's something that you can work on with interns, for instance, to help them get better and more comfortable with talking to people as they come out of court. And this was something where you definitely want to have an in-person interview with them so you can get a sense of their friendliness and their ability to just walk up to a total stranger and start talking. Other questions?
So Emily asked, Emily from New York, how did we decide which subset of access and fairness questions to ask? As I think, as Jamie's mentioned throughout, sort of, what your goals are determines what data you're collecting. And so, the Lonnie and her department has sort of asked about, had expressed interest in particular things, satisfaction, and so forth. And so we sort of chose the ones from the Access and Fairness Surveys that more closely lined up with what we were interested in asking about.
And we weren't as interested, to be honest, in some of the access questions. If you're familiar with that, there are questions about access to the court itself, like they remove physical barriers for me. Something like for the landlord tenant, that isn't directly addressing what we need to get to. The website, for me, the website question is not particularly helpful because a lot of people just answer that who've never even seen the website at all, and they're just like, they're neutral on it, and it's hard to get to people who have or have not used the website. So that, and again, that's not one that we're particularly is not a question that's really relevant to that particular evaluation. If we wanted to know about whether the website was helpful, we could ask that question. So I would recommend overall, as Justin said, really think about what you're trying to evaluate. What are the goals of the program? And based on the goals of the program, try and align that with the questions from the already available questions, ones that have been vetted, or if you need to ask different questions, then do that as well.
We worked really collaboratively together too on these questions. We went back and forth and tweaked little things, and I'm just kind of laughing and thinking back to the process. It wasn't like we sat down for one meeting and just, made a decision. There was a lot of collaboration and back and forth.
Probably more rounds than our good friends in Access to Justice would have preferred, but yeah, it was very
Now you
collaborative.
get to hear how everybody really feels.
Other questions?
Angela from Colorado. These are so the parties do have to come to the courthouse for the video conferences with the Self-Help Center. And then I'm sorry, I know I think what was the question about the wait time, comments about wait times? What was the response to that? That re-upped that question. Sorry.
Oh, well, Lonnie, you might be able to talk just generally from the program data, what we know about the wait times at the walk-in centers. I mean, we have better metrics, I think, for the wait times for call, for sure, because they're monitoring that all the time. For the walk-ins, we didn't get a lot of comments, as far as I remember, that were particularly addressing that. And if anything, they're all positive. Like I said, when people walk out, when we're doing the exit surveys for the Self-Help Center, sometimes you can't get them to stop talking. They just want to keep telling you how great it is, which is fantastic. We love it. Whereas, we have a very different issue with the exit surveys, the court exit surveys. But so Lonnie, can you talk a little bit about that?
The wait times for the walk-in centers vary so greatly, and it depends on a number of things. One of the things is our walk-in help centers, with the exception of the district court ones, are not as unified. So family law help centers may be open full-time, 8:30 to 4:30 court hours. Some have extended hours in the evening. Others in some of the smaller jurisdictions may only be open for a couple of hours one day a week. And for those programs, you may have to get there at 9 and sign up and hope you get a slot. So in that case, wait time data, is not great. You may get there and not even be able to get assistance. For the district court help centers, which are run by that one provider that we talked about earlier, we didn't even collect wait time data. We had attorneys sort of estimate how long the actual consultation was, but not how long people waited before they got the help. We recently changed our data collection procedures to a new system which allows the attorneys to check out the encounter, and it sort of starts an automatic timer. So I expect in a year or so we're going to have a lot better data on the amount of time between when the litigant sort of checks in at the help center and then actually gets to meet with an attorney. But we just don't have that data historically for the walk-ins. And then again, it varies so much depending on the jurisdiction. But we do have a lot of really good data on live chat and phone. It's automated, and we can tell you exactly what the wait times are, for months or days or years.
Any final questions? Justin?
If anyone else has any, or
All right.
I suspect we've come to the end of the session.
We are. Well, thank you all for attending, and thank you for your time. And we've really enjoyed coming and talking to you about the way that we're using data in our self-help or help and legal services programs. And if you have any follow-up questions, you can feel free to get in contact with any one of us. So thank you and have a great day.
Thanks for bearing with us.
Yes.